we're going to move on to the next topic, which is staff and associates. Your associate, whom you have no agreement in writing with, decides one day to leave, to take a patient list, a list of patients, to basically tell you that they're taking staff to set up shop across the street and start competing with you. Is that legal? What do you guys think? Perfectly legal. Okay, sir? Yes. Why do you think it's legal? So if you were the principal dentist and you sued this associate for doing all these things, you think a judge would say, there's no contract, I can't help you? You are right. And it's amazing to hear that, because we never hear dentists saying that that's the case.
You might be the first one that's ever answered in that way.
So here's how it works. There's a number of court cases out there, and I have a future article that's going to be published in Ontario Dentist about this topic. A dentist who's an associate who works exclusively on patients without a contract can set up shop across the street, can take a patient list, can tell you that they're taking staff as long as the staff has given you appropriate notice, can notify those patients that they've dealt with exclusively through business cards, letters, and general advertising that they are now setting up shop, and there is nothing you can do. Indeed, one dentist called us up and said, I'm in the process of doing this, and I had to settle because I found out I was wrong. I ended up suing an associate who went across the street, took staff, took patient lists. I had to pay her $50,000 to settle the lawsuit that I started because the judge said I was wrong.
When it comes to staff contracts and associate agreements and these restrictive covenants, it's not just good for you in terms of looking at a transition plan because it's something the buyer will want to see. It's also good business practice for you as the dentist and the business owner during the lifetime of that ownership of the practice. So sometimes it's not always about what's good after the fact. Sometimes things good down the road are also good today.
Yeah, we've seen 2 deals die because the purchaser wanted to buy, everything was set to go, but on the day of the closing, the staff didn't have contracts in place. There was no contracts with the associates, no non-competes, no non-solicits, and said, too risky, backed away. And we're talking the day of the closing, backed away after all that work had been done. So make sure, if you're the seller, have those contracts in place. How do we do that? Do we just present contracts to our staff and associates? David, how do we recommend that you present staff and associates with contracts?
Oh, we recommend you hire us.
Oh, okay, that's a good idea. Yeah.
There's a lot of, in fact, I would say that today employment has almost become like a human right, at least in the province of Ontario. So you have to be very careful when dealing with staff if you're going to look at doing a contract with them after they've already been working with you. And a lot of times we've seen dentists who are 20, 30, 40 years into practice, they end up hiring someone when they first started. They've been together for 30, 40 years, and they just think, oh, you know, they're like my sister, they're like my brother, they're like my best friend. Everything's going to be perfect. I don't have to worry. And I think you might have heard this from George earlier today. But if you present someone with a contract long after the fact, and there is differences to what they had been working for already, it gives rise to a potential claim back against you, or if it's your professional corporation, from that employee. So it's really important that if you're going to try to put someone on contract that hadn't been on contract before, you get the proper legal advice to make sure you're protected, because there's legislation and court decisions that sort of set out a series of rules to follow to keep yourself out of trouble.
Yeah. I wanted to talk briefly about a point that was raised earlier. Do I have to pay my employees severance or give them notice when I'm selling? Sellers don't generally like to tell their staff they're selling, and they sure as hell don't want to pay them anything because they may not have a deal until the very last day. And why should the seller have to pay if the employees are just staying on? So in the case of a share sale, which is preferential for sellers, what normally happens is, like George mentioned earlier, the staff are notified the day of the sale or in and around that area, and afterwards we start talking about liability. Who owes what if the new purchaser decides to get rid of staff, especially staff that have been there for 20, 30 years. There's a lot of built-up liability, a lot of notice, or a lot of severance, which is a common vernacular that is used, that is owed. So who owes that? And typically the deal will be structured such that for a set period of time, like 3 months, the parties, the vendor and the purchaser, will split the termination costs. After the 3 months, the purchaser's on the hook for all the termination costs. Okay? So the vendor is not on the hook typically until the day of the closing, and then after, they may be on the hook for a little bit of time. We've seen 3 months, we've seen 6 months, we've seen the vendor's responsible for the first 3 months, and then it's split for the next 3 months, and then the purchaser for the remainder. Does that help clarify the situation of what the vendors go through?
And these are things. We'll come to your question in a second. These are things you'll find that a buyer should, and a buyer, I've never seen it not be the case. They'll have their own lawyer, and their own lawyer will try to advocate for the buyer's behalf, and they'll try to ask for terms with the seller that are beneficial to the buyer. For example, you have to pay, even if I've got a staff member for a year, it might take me a year to figure out if I like the staff or not. If I terminate them after 1 year, you pay all the notice or severance, which is a common expression, you pay all those costs. Your lawyer will say, wait a second, the deal's done, we want to go forward, we don't want to be looking back, and they'll try to structure something better for you which reduces your potential exposure to costs that could be payable to an employee if there is a termination.
You got a question?
Yes, my question was just about the logistics. Are you going to hold a certain amount in trust in the meantime? How do you go about it?
It's
If the seller walks away,
Mhm.
how are you going to get him to pay that?
it's it would be great if there were holdbacks or monies in trust, but typically parties want clean breaks. So there's an agreement in place. If you break that agreement, you have to go to see a lawyer and get maybe sued or sue somebody. So there's a lawsuit.
Dentists don't tend to be people who take the money and run. Dentists tend to be people who don't become judgment-proof or asset-proof after a sale. Dentists tend to own, usually they tend to own their own home, they might own an investment property. They're not, a fellow dentist is not someone to necessarily be afraid of. Sometimes after a transaction, there's a dispute whether one side might owe a few extra dollars back to the other side. It usually gets resolved because court cases make everybody lose, except the lawyers. You are correct.
Yeah.
But it's not the case if somebody purchased the assets, right?
This is very interesting.
Excellent question.
Yeah.
Excellent question.
I'll do this. Can I do this?
Can I give him the tequila for that question?
No, he's got to solve my riddle. Do you know the answer already?
Yes.
What is it?
Tell the class. What's
No,
the
I'm
answer?
just kidding. Okay, so if you're going to sell assets, let's say you've used up your lifetime capital gains exemption. You've used it all up. You've been buying and flipping practices your whole life. You've got nothing left. Your accountant, DCY, says, sell the assets. It's better for you. So what happens is, again, you don't want to tell staff that they're being let go. On the day of the sale, okay, if you sell all these assets, the purchaser is going to inherit all of the liabilities of your staff. And you're going to have somewhere in their agreement that you're taking my staff on substantially the same terms as they work for me. And the purchaser is going to say fine. So they take them. And guess what? They inherit all of the previous notice and severance that they built up with you. They carry it forward. The Employment Standards Act basically says the only way to get around that is don't hire them for 13 weeks. The purchaser cannot hire those staff for 13 weeks. Then they get new employees, assuming they're still around. Nobody ever does that. The purchaser needs those staff, keeps them, so when we represent the purchaser and the purchaser is buying assets, and we know the purchaser is going to inherit all these liabilities from before the closing, what we do is the next day we have a pizza party. Hey, guys, this is the new owner of your dental practice, and we're going to give you this letter, and it's basically going to say your employment with the vendor is coming to an end in a set period of time. That's your notice. When that notice period expires, I'm going to present you with new employment contracts, and you're basically going to be new employees. So that's how we kind of manage the risk for the purchaser so that they're not inheriting and maintaining all that pent-up liability. Does that make sense?
But if selling the shares have the same liability as well, right?
Unless prior to the closing, the vendor gave everybody notice, which never happens. It may happen once in a blue moon. Otherwise, all that you're doing when you're selling shares is changing ownership. You didn't change the relationship that that company had with its staff. Those contracts are still in place. You just changed the ownership. Okay? So somebody new stepped in and said, I'm the new owner of this company, but the company's contracts are still in place. So unless you give notice or pay notice, everybody is basically going to be still liable.
I'd like to, just before we get to your question, I'm going to do a bit of a, it's connected, but a bit of a tangent for about 30 seconds. The question before was, when do you tell staff? Do you tell patients if you're a seller? So it sort of fits in with this whole presenting existing staff maybe with notice or new contracts of hire. One thing you have to keep in mind if you're the dentist, it happens a lot. You freeze the patient's mouth, you go to another operatory. Who's left with the patient? Chairside assistant, the hygienist, someone. They talk a lot. The risk of telling people, the staff or the patients in advance is, the risk is people get scared. You heard that with the staff. What if I don't have a job? What if I don't like the new owner? I better protect myself, look for work elsewhere. And they start telling the patients. And then the patients say, uh-oh, I'm going to have to get a new dentist. I'm not prepared for that. Well, I happen to know my neighbor's a dentist or my cousin or my friend, and they start looking to move. The patients could diminish, the staff could diminish. Collectively, the word goodwill, another sort of an intangible way of valuing your practice, diminishes. Be very careful because not every deal closes. Sometimes a deal falls through and you have to sell later, and that might be 2-3 months down the line, and there's some attrition in there. You have to be careful.